Yeah. Oh, well, all right, my phone.
The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. This is Ryan Thurman with Contact Center Compliance here today with Joe Samstrand.
Hello, everyone.
Welcome to our feature webinar today about the recent updates we were able to ascertain from the ATA's Washington Summit, which occurred about 2 weeks ago out on the Potomac. It was a wonderful event, and they had some great speakers. Unfortunately, a lot of the industry was able to attend, and a lot of the presentations were so full of content that we thought it was a good idea to take some of that information and use it as a discussion forum with some takeaways for folks that are in our compliance circle.
And it was an excellent DC convention, I got to say, just in terms of the political figures that were attracted to this ATA convention in Washington, D.C. I just thought it was amazing. I really think it represents the culmination of the ATA's work in the Capitol, trying to get the word out about the telemarketing industry. And by the word, I mean that the telemarketing industry creates jobs. And I don't know if anyone else has noticed, but you may have seen every single politician in Washington fall all over themselves trying to be seen as a person who creates jobs. And it was just fascinating to me that at this time in Washington, there was a time going back not even that long ago, 3 years ago, 4 or 5 years ago, where telemarketers on Capitol Hill were considered, you know, I don't want to say anything too strong, but let's say it was difficult to get a meeting with representatives. If you just went in and said, hey, I'm a telemarketer, or I'm with the ATA. And yet here we are, the ATA, going to D.C. for our annual Washington, D.C. conference. And who do we have? We have the director of President Obama's Jobs for America program. We have the chairman of the FCC, and we have the director of the Consumer Bureau Protection of the Federal Trade Commission. And wouldn't you know, every one of them talked about the importance of creating jobs. And every one of them really applauded the ATA and the telemarketing industry because of its ability to create jobs. And I think, you know, of course, every meeting and convention that the ATA hosts is a good one, is important. This one was especially important. And, of course, Ryan and I are going to go through the information that was imparted by the various presenters. But the best way to experience an ATA convention is to become a member of the ATA and actually go to the convention. And in addition to all of the keynote speeches, you have all the educational sessions, you have all the networking opportunities. And for anyone who's on board who is not a member of the ATA, I strongly encourage you to go to ataconnect.org and become a member right away. So Ryan, back to you.
So just a little bit of some housekeeping items on today's webinar. We are going to have a recorded version available. We'll get that out to the attendees with the slides. If you've been on our webinars before, usually expect that about a day out. So that'll be something you can forward around your company if you need to, or go back on some of the notes that we have in the slides. In addition to that, we are going to have some time for a question and answer period at the end. So on the GoToWebinar toolbar, they have a little text input screen. Just type your questions in, and we'll get to them either throughout the presentation or at the end as time permits. That's our contact information on the screen, and also what we look like if you see us at one of the conventions. You'll be able to find us. We threw together kind of a agenda that I'm not going to go through every single one of these points because it's really, a lot of this is within the actual presentation itself. But give you kind of the short version. We're going to cover what the FTC had to say from the ATA's Washington Summit, what the FCC had to say, what the ATA's General Counsel had as far as federal updates, take a look at some of the liability issues that were talked about, also a quick update on the international compliance front, and that covers some of the privacy laws that are recently passed. So, and we'll probably spend a little bit of time on each of those subjects as we go along.
Sounds about right.
So I was fortunate enough to get a chance to actually meet Louis Greisman, who had the session, and hear what she had to say, ask a couple of questions during her presentation. But what I thought interesting from Louis Greisman was some of the tactics and help she was asking for from the industry was a big theme of her presentation. She had two main points that she was trying to get across, and Louis Greisman is the Associate Director of for the Bureau of Consumer Protection. So she's really kind of in charge of the global Do Not Call program, and they have a new Do Not Call list coordinator who's actually managing the actual list. And so the two main themes that she had to convey were that, A, she wants the help from the industry to stem some of the issues related to robocalling and voice broadcasting that are persistent. And I'll get into some of the stats she had on that, where they're looking for help to identify companies that are involved in illegal voice broadcast or pre-recording calling / robocalling. And number two, that they are active. The other theme was that they are active in enforcement, and that they are going after some of the industries that are out there that are targeting especially the disadvantaged economic situation, and that they have a few cases that she pointed to which were worthy of taking a look at. So their primary goal is protecting consumers from fraud and privacy issues. One of the things that she mentioned, which is a good thing to look up for your organization, is they have a new staff report on privacy. It talks about privacy by design and streamlining data, and has some recommended measures, which I believe is on the FTC site. The other is protecting businesses with enforcing antitrust regulations. I never want to have to find myself in the middle of this building down here in Washington, D.C., but they have some very specific mechanisms, which I think a lot of people aren't aware of, the amount of leverage the FTC has. She mentioned that the FTC has powers of civil enforcement. They can go in and shut down businesses. They can freeze assets. They can institute consumer redress. And they can also take over or assume operations of a company.
Well, that'd be nice, wouldn't it? Have somebody come in and take over operations?
Exactly.
Sounds like it would make our lives easier.
Yeah.
And Ryan, I'm of course kidding, but one thing I wanted to say about privacy before you got off the slide here, for those who have been kind of watching the FTC attempt to address privacy issues, we've seen, I don't know if anybody knows about the red flag program that the FTC keeps coming out with and then delaying the implementation of. The FTC is really the federal agency that would be tasked with trying to come up with some framework for data security and data privacy. And this Privacy by Design staff report is the FTC's latest attempt to try to put out a set of best practices for businesses in the United States to try to address the very, very real issue of data privacy and protecting people from identity theft. And it makes for good reading, and it's readily available on the FTC website, as Ryan just said.
Moving on to some of the examples that was shared at that presentation. This is on the second day of the agenda. She went through a lot of the fraud issues that they're seeing in her office, and they range from everything like job scams, where people have to go apply for some special certificate in order to qualify for a job, which is totally bogus, or work-at-home scams. They're seeing a lot of that stuff where somebody's trying to get into collecting money off of, employment opportunities. They see continued issues with credit and debt negotiations and credit repair, homeowner relief, home modification type situations. They also had some enforcement action recently against some timeshare resale offers, medical discount cards, investments, and government grant type things.
Right. Anything that kind of arises or is exacerbated by the current economic situation, the FTC has really honed in on from an enforcement standpoint. So entities that are in the work-at-home field, in the credit repair, in mortgage renegotiation, any of those things, a lot of them have found themselves under increased scrutiny. And just makes for interesting enforcement, as Ryan will talk about. And so for those entities that do these different sorts of things, you really have to be extra careful to make sure that you're complying with certainly the telemarketing sales rule, but of course everything across the board, because it's not just the Federal Trade Commission that's paying attention to these issues, it's also state attorneys general.
And one thing I think that was mentioned, it was either in her speech or another one, was that there is a sharing of data between the attorney generals and the FTC, and they kind of have this pooled resource when it comes to complaints. Which
they sure do.
Yeah, I wasn't aware of that.
Yeah, they have a thing called the Consumer Sentinel system, and it's almost like you have the FTC there in D.C. and all the state AGs across the country. All the state AGs are feeding complaints that they get into the Consumer Sentinel system that's run by the Federal Trade Commission. So they really do have a nationwide database of complaints against companies.
So
Ryan,
what
are
I
you
was
there?
going to do
Oh,
is, I was just going to kind of highlight some of the recent enforcement summaries. Lewis didn't talk about this, but it came out yesterday, which was that Google had settled a case with the FTC around their Buzz product. That was within Gmail. There was sharing of your contact data without your consent. It was something the FTC had been fighting with Google for a while on. It's definitely worth reading about, because it covers a lot of the privacy issues. The other case that's kind of ongoing that was alluded to by Lewis was the Dish Network EchoStar case, where essentially Dish has been fighting, or at least posturing for a type of safe harbor type defense, and there's a continued investigation on that front. That already was involved in the FTC's press releases. There's a release regarding Dish dealers that already settled, so that one will be remain to be seen. But the other enforcements that I pulled out of the FTC's press releases all relate to these fraud examples in a lot of cases. Credit repair, job scams, more credit repair, deceptive mortgage, and then this one was a little different, but it was a fairly large settlement with Reebok for $25 million in consumer refunds for these toning shoes that essentially didn't work. So,
hey, they worked for me. Okay, I'll stop. Okay.
I'm not a Reebok guy, so I wouldn't.
It's just off on the phone, right? No, just kidding. Go ahead. Sorry.
And I did get a comment from another group that's on the phone that deals a lot with investigations, another legal group that we've done some work with here. And they actually affirm that they're seeing a lot of civil enforcement actions in a lot of those areas that we mentioned earlier. So I think the theme is, hey, if you're in any of these lines of work, you really got to have squeaky clean compliance. Just by virtue of being in that space, it's going to lend itself to escalated consumer complaints. So let's jump over to some of the facts and figures that Lewis threw out. I was trying to get all these down, and I think I got most of them right. She mentioned that they have this consumer complaint call center. In addition to the web way you can file a complaint, there's also a call center that handles complaints to the FTC. Last year they had 1.4 million complaints. In the fiscal year they had 2.2 million. So I would say out of how many millions of telemarketing calls that are made, that's not terribly bad. But the bulk of their complaints are against the pre-recorded robocalls that people are still getting. And they actually have a separate complaint process now for robocalls. So if you go in there and file a complaint that it is a pre-recorded robocall, they send that down a different path, which sounds like it's fairly escalated. She stated that in the first half of 2011, the number of complaints on robocalls exceeded all of 2010 for a total of about 800,000 complaints. She was asking the industry to basically say, hey, look, these robocall companies and these dialing campaigns are giving you guys, ATA, the compliant companies, a bad rap. We want your help to identify who some of these players are. They seem to have a pretty good handle on it because she mentioned that they were tackling not only the dialing platforms, but the resellers, the brokers, and the end users, trying to put a squeeze on everything. Overall, the FTC has brought 79 do-not-call cases, $40 million in fines, and over $500 million in awards. Let me go to my last slide on the FTC. She talked about two cases that are worth looking at because they pointed out a couple different things the FTC is very keen on enforcing. One is the Electric Mobility Corporation settlement. This is where they were using sweepstakes forms for a, quote, EBR override when the telemarketing sales rule specific doesn't allow that type of a promotion, and so EMC didn't comply with it, and kind of listed the high points on the case here, where
right,
you know,
and sorry, go ahead, Ray.
No, go ahead. No.
I was just going to weigh in. You know, this is an issue that I deal with quite often. That comes up all the time for those entities that run some sort of sweepstakes or some sort of prize giveaway, whatever. What does it take in order to be able to call those people if they're on the do not call list? And the quick answer is just because a person enters a sweepstakes, that doesn't mean they're making an inquiry to your company. Just because a person has entered a sweepstakes that you offer, it doesn't mean that you have an established business relationship with them. I guess that's just common sense. But even if on the sweepstakes form itself, like what Electric Mobility Corp had, even if you have something on there that says, you know, by putting in your number, you're giving us consent to contact you. And actually, Electric Mobility Corporation had something in there that said, you're giving us consent to call you if you win. But of course, they use that to call and make follow-up telephone solicitations. That's not enough. If you don't have inquiry, if you don't have EBR, you got to go for express written consent, and that means getting some sort of writing signature from the person. It could just be a checkbox where they mark off the checkbox, but include language along the lines of, by checking this box, I'm signing this form, and I'm giving my consent for Electric Mobility Corporation to contact me, even if I'm on state or federal do not call list. That's the extent that you need to go to if you want to be able to call do not call numbers off of a sweepstakes form. If you don't have that, or if you don't want to do it for whatever reason, well, you can still call people who are not on the National Do Not Call list, but you should stay away from calling those people that are on the National Do Not Call list.
Let's move on to the other case that she mentioned, which was feature films for families. This one had a pretty large amount of liability, 16 million phone calls on national DNC.
And the fine for each call is $16,000 now?
Yeah, $16,000, and what they stack on in this case is failure to convey proper caller ID, not disclosing, abandoning calls. So they can take those 16 million calls and times 1, 2, 3, 4, And on top of that, a do not call violation, that's times 5 per incident, so they can stack it up. And
right. The total amount the FTC could go after here is apparently $11 billion.
Yeah, my calculator doesn't even go that high. So that's pretty egregious violation. I mean, 16 million. If you're making 16 million phone calls and you're not aware you have a compliance problem.
Yeah, that's yeah.
Normally, if you have a compliance problem, it comes out pretty quickly. So, we jump over to some of the information they had from the data book. I think we shared this on a previous webinar, but I mean, basically, I heard the FTC say there's 209 million numbers on the list. Well, there's 209 million numbers on the list, but about 8 million of them or so don't have a corresponding area code that exists anymore. So I would say what I've seen is there's more like 201 million on their list. Number of companies getting a full SAN number. Guess what happens when you get a large do not call list? You don't work with the industry to preserve jobs. You get numbers like this where, you know, there's half the number of companies that buy a full SAN number as there was in 2006. So it's pretty staggering what amount of companies are out there that are actually, you know, going out and registering these days.
Mm-hmm.
Let me jump to the next screen. We keep a live database on our solution around where do not call numbers are in the United States, and you can kind of see that generally most states have a pretty high population of PNC numbers, and there's some kind of pockets that are notoriously harder to get clean leads in on our little map here. A lot of times you'll see it's above 100% everywhere because you get multiple phone numbers per household. Let's move over to Joe's going to give us the update from the FCC and from the Jobs for America guy that was there.
Sure. And as I was saying before, it's wonderful to have Washington luminaries beat a path to the doorstep of the ATA. It's about time, and again, this is the payoff for years and years of the ATA's very patient work on Capitol Hill, spreading, you know, one simple message, which is that the telemarketing industry means jobs. And if you're over-regulating the telemarketing industry, guess what? You're losing jobs that otherwise should be there. And so President Obama has an initiative called Jobs for America, and Jim Kohlenberger, who actually worked in the Clinton White House and before his current role, the Obama White House, he is the executive director of this program. And some of the data points that he made in the course of his speech was that IT drove 85% of job growth in the 1990s. So, of course, investments in information technology are very, very important in relation to jobs within any country, and certainly the United States. But he said that the U.S. is behind the curve on the use of broadband technology. He says 100 million people don't have access to broadband. So the plan that has been put together by the Obama administration is that they're going to work to connect America through smart grids and infrastructure, and this includes not just broadband infrastructure, but energy delivery infrastructure as well. President Obama can take credit for creating the first broadband strategy at the federal level and also the nation's first technology officer. And as part of this program, the FCC has proposed spending $5 billion to help make broadband universal. And part of the goal of making broadband universal is to overall reduce telecom costs, including voice over IP. And we'll have a little bit more to say about the FCC's plans for universality of broadband on the next slide. Also, President Obama has issued an executive order to make 4G wireless available to 98% of Americans. Now, I honestly don't know what 4G is. I missed the boat Was there a 1G and a 2G, Ryan? I don't know. Was there?
Yeah, we have most of them have 3G these days. Verizon's got some 4G, and AT&T and some other carriers have that as well. That's the next generation wireless, higher speed solution that everything's kind of gearing up for.
Right, right. Yeah, I'm afraid I've fallen behind the curve a little bit when it comes to the latest in I don't know, the latest gadgets and the latest in technological terms. But yeah, President Obama wants 98% of Americans to have access to 4G wireless. It's part of President Obama's plan to increase investments in research and development. He wants to get back to having R&D be the equivalent of 3% of the gross domestic product, and that the goal, the reason that they chose 3% of GDP is that during the space race, that was the percentage that was being spent on research and development. And also, and you know, politicians never say this, President Obama says they want to change how government does business. They want there to be more openness, and they want to make smarter use of technology. And we'll see how that plays out and whether or not that actually gets implemented. But the fact is, right now, as I mentioned, Washington's top priority is jobs. Virtually every politician that you see on TV, whatever they're being interviewed about, they will try to get a word in about how they are in the process of trying to create jobs or trying to reduce regulations to create jobs or trying to increase regulations to create jobs. Whatever it takes, they just want to be seen as being a person who's out there working to create jobs. And the fact is, telemarketing has created 4,000 jobs a month for the past 2 years, and that's why the APA and the telemarketing sector is so attractive to our friends in Washington. So let's go to the next slide. And then Julius Janikowski, chairman of the Federal Communications Commission, he came on board and he gave a keynote presentation on, I forget, day 2 or day 3 of the ATA conference. And of course, the FCC applauds the Job for America's goal of getting 100,000 new U.S. jobs in the contact center industry via the expanded use of broadband. The key concept here, the key takeaway here is that broadband technology, wireless technology, better broadband technology is seen as the key, at least from a federal jobs development perspective, to ensuring America's competitiveness in the world economy. And so a lot of focus has been put into broadband. Some notes on job creation and the telemarketing industry that Mr. Janikowski had. Onshore call center jobs are making more and more sense. If you go back 4 or 5 years ago or even 3 years ago, there was a lot of focus on offshoring, nearshoring, coming up with strategies to better manage and control what you were doing in the offshore, nearshore environment. And a lot of people, not just Julius Janikowski, but a lot of people have said, you know, there are some hidden costs associated with outsourcing and going offshore. And given some of the improvements being made in broadband, in wireless technology, and also home-based agents, the cost equation associated with going onshore for call center jobs has changed to the point where it's making more and more sense to work onshore as opposed to outsourcing. And also another point he made is that the fusion of email, chat, and talk that perhaps has taken longer to actually occur than what people may have anticipated a few years ago, but it is in fact happening. The agents in the telemarketing space need to be better able to make sure that they can handle email, that they can handle chat, and that they can handle talking on the phone, and be able to go from one to the other at a moment's notice, because that is more and more becoming a requirement in the space. A big program at the FCC, really over the past century, has been universal service. And when we talk about universal service, we were just talking about the universality of telephone service, landline telephone service. And what Mr. Janikowski believes is that the same concept of universality should apply to broadband. And so what the Jobs for America executive director was talking about, the $5 billion aimed at making broadband universal, this is the FCC's Connect America program. And it sounds like a laudable program, basically ensuring that all people in the United States have the ability, just the same as they have in the landline arena, that people have the ability to access broadband and be able to communicate and do business making use of broadband. According to Mr. Janikowski, this might require reallocation of existing spectrum from older uses, and this is a really key, important focus of the FCC moving forward. How to ensure, the spectrum there's only so much spectrum out there, only a finite amount of space. How much has to be allocated to broadband in order to maximize the impact of broadband in job creation and economic development. So let's go on to the next slide. Okay, so the challenges facing the United States regarding broadband usage. First of all, as I just mentioned, the spectrum crunch. There's only so much spectrum out there available for wireless service, and the FCC recognizes that, and also recognizes that if you don't devote enough spectrum to broadband, that's just going to result in higher and higher prices for broadband, so they have to be very careful about how that process occurs, how the allocation process occurs for people making use of broadband. According to Mr. Janikowski, 20 million people in the U.S. Have no access currently to broadband technology, and 100 million do not use available broadband. So, to a certain extent, there's a skills gap in place. If you have 100 million people who have access to broadband who are not making use of it in any way, shape, or form, well, perhaps that's a reflection not on the people, but on the fact that they're not in in an industry, or they haven't been given the education, or they haven't developed the skill set to take advantage of this fantastic technology that enables very, very quick communication and transfer of large amounts of information from one person to another. And this is something that the FCC hopes to address. And then, bottom line, the bottom line message that Mr. Janikowski wanted to deliver to the ATA, and in effect to everybody out there, is that development of the information grid and proper deployment and adoption of technology is the gateway to better jobs and better living in the United States. He really sees broadband and making sure everybody has access to it as the key factor in ensuring the United States' competitiveness in the global economy. All right, let's go on to the next slide. Okay, Mitch Roth, General Counsel for the ATA, provided an update with regard to some of the issues that are being addressed at the federal level. The first item that Mitch brought up is caller ID. The federal government passed a bill called the Truth in Caller ID Act. And a lot of people had questions about, well, how exactly is that going to impact the delivery of caller ID? And what about situations where a telemarketer, for whatever reason, doesn't want to transmit the caller ID of the number from which the telephone call is being placed? Maybe the telemarketer wants to transmit a different 800 number, or wants to transmit a number that is local to the person who's being called. A quick look at the statute itself would have said, well, that might be a violation. But Nobel Biz went out there and won one for the industry, and basically won the argument over whether or not the telemarketing industry can, in fact, go ahead and send off caller ID signals that are different than what would normally go out from the location of where the call was being made. And that's very important because it gives more leeway to the telemarketing industry. Basically, so long as you're not sending off a caller ID signal for the purpose of defrauding the person to whom the call is being made, you're able to go ahead and do what you need to do. The FCC is currently seeking comments with regard to liability issues, and Ryan touched on this just a little bit before. This is the Dish Network case. Dish Network is the way that they market their satellite services is by having third-party entities, separately incorporated entities, go off and offer the services that are offered by the main corporation, which is Dish Network. And for various reasons, it has come back to the FCC to address the question of whether or not liability can be imputed to Dish Network under that scenario. And a lot of people have submitted comments on it. The ATA submitted comments on it. And we'll see how the FCC rules on this. It's probably going to rule sometime within the next 6 months. There have been a spike in complaints regarding pre-recorded messages, which is somewhat surprising given the fact that, the FTC came out and said if you are sending off a pre-recorded telemarketing message, you can't do it unless you have express written consent. Of course, the motivation of sending off a pre-recorded message is that it doesn't cost a lot of money to go ahead and do so, and a lot of people are just lured into sending off pre-recorded message campaigns, and different people come up with different ideas for how to get around that express written consent concept. But the fact is, more often than not, the FTC doesn't accept the rationale provided for sending off a pre-recorded message if that pre-recorded message is even indirectly related to a sales campaign. And the FTC has pledged to vigorously enforce the TSR with regard to pre-recorded messages. Now, when it comes to survey calls and political calls, that's a whole different thing, obviously, but for telephonic solicitation, you really need to be very careful. There is a pending pre-recorded ruling by the FCC, and the ATA has submitted comments to the effect that non-sales calls should not require express written consent. And the genesis of this is the FCC taking a look at its rules regarding pre-recorded calling, which are different than the Federal Trade Commission, and trying to figure out, okay, well, if we, the FCC, adopt the Federal Trade Commission rules regarding express written consent, the issue there is that all of a sudden under the FCC rule, express written consent could arguably apply across the board to all pre-recorded calls, independent of whether they are for sales purposes or not. And so the ATA has submitted comments to the effect of saying, yes, you, the FCC, should amend your TCPA regulations, but you should amend them in such a way that they really do comport with the FTC rule. The FCC is also considering requiring written consent for calls to cell phones, not just express consent. This is another area that the FCC is addressing and has invited comments from consumers and entities out there. And then finally, the Obama Deficit Reduction Plan, which has been submitted by President Obama, would amend the TCPA to permit calls to cell phones to collect debts that are due the United States government. And the purpose of this is, okay, to help with deficit reduction, obviously. And currently, it's under the TCPA, it's what Obama wants to make clear is that it's acceptable to make calls to cell phones even where perhaps the individual did not submit the cell phone number during the transaction that resulted in the debt itself. The FCC has already come out and said, okay, if the original transaction the person filled out a form and submitted the cell phone number, you're allowed to call the person on their cell phone for purposes of debt collection only. President Obama wants to expand upon that. And then beyond that, Representative Terry has proposed a bill that would redefine the FCC definition of auto dialer. And this is a key point going back to when the FCC took a look at its definition of automated telephone dialing system, and this goes back, I don't know, 8 years ago, and said, you know what, when we, the FCC, think of automated telephone dialing systems, you know, we think that means a predictive dialer. And a lot of people scratched their head and said, well, wait a minute, the TCPA clearly says that an automated telephone dialing system refers to a system that generates random or sequential dialed numbers. How could that be a predictive dialer? Well, the FCC just went ahead and the industry has had to comply with that interpretation ever since. And the Terry bill would say, well, wait a minute, an auto dialer is only a system that does random or sequential dialing. And also, the Terry bill would include EBR as prior express consent for calls to cell phones and would permit info-only calls to cell phones, just directly allow people to send info-only calls to cell phones. So that is the update at the federal level. Ryan, I'm going to turn it back to you.
Thanks, Joe. Certainly a lot going on across the board.
Mm-hmm.
Did you want to talk about the liability under the TCPA?
No, for right now, I'm going to say I think I've hit that quite a bit recently, so I'm going to give everybody a breather on that topic.
Yeah, and some of the notes are in here from where that came from, and we just talked about the FCC.
Mm-hmm.
So that's good. I think we're going to close with a little recap of what's going on in the rest of the world for folks that have calls to Canada or other parts of the country. So just a couple quick updates. Number one is the fee for the Canadian Do Not Call list is skyrocketed to like $33,000 a year for the full access to the country effective September 1st. Canada also has a new anti-spam law that I think goes into effect in January that isn't worth looking into. Mexico just passed a new data protection law that's fairly substantial, and any data that goes to Mexico, goes to an outsourced firm down there, has to comply with it. So if you're an outsourcer and have seats down there, expect to probably see some reference to that underneath the client's responsibility. We also saw a data privacy law in India that has a lot of people kind of wondering what was really the deal, and they came out with a press release a few months later that said, well, if you're not based in India, you don't necessarily need to comply with it. So that was alleviated a lot of concerns. And there's some other countries with Do Not Call lists that have some decent enforcement, like Australia. Canada also went after and fined Bell Canada, which was kind of strange because Bell Canada actually runs the list. So that was recent. They also fined a firm called Zentel for about $500,000. So stuff going on in those markets, and you also we saw a new data protection law in Costa Rica that requires a registration and fee every year. France, Singapore, and Korea all have data privacy breach type notifications. California had a new enhancement to our privacy law out here, an enhanced breach notification piece where you also had to, it was like over 500 instances or some number, I can't remember what it is off the top of my head, but you have to notify the Attorney General's office and provide them a copy of the breach letter, and that tends to push other states to copy our laws out here for some reason. As far as resources, when it comes to privacy and those kinds of things, there's the IAPP, which is really good. They have a daily digest. There's some LinkedIn groups like when we run contact center compliance. There's some other privacy groups within the financial markets. Other ways to stay updated with what's going on in the industry. Obviously, going to an ATA event is a nice advantage. Tuning into a webinar also helps. We have a compliance guide solution that we maintain, and we try to post updates in there. We have an industry newsletter.
Ryan, isn't there an incentive for people to get the Contact Center Compliance Guide?
There is, actually. I'm glad you asked. For a short period of time, we're offering a free iPod with the purchase of a compliance guide, and actually buy the compliance guide on a monthly basis, which is nice now. And the cost isn't that bad. You're only looking at like $149 a month or $1,200 for the year if you buy it in bulk. So it really got everything that you need as far as comparing federal and state rules, and it's the only solution that simplifies the process of state registration, going through the 32 states, trying to figure out where you need to register, what your exemptions are, and making sure that's done correctly.
Right, and it's also the only solution that takes all of the information out there at the state and federal level and really puts it into a true database. So the information is not just static. You have the ability to go in and generate reports within the online environment, and you can pull whatever information that you want from whatever state that you want and do comparing and contrasting, which is a very, very useful tool.
Definitely, and if anybody's interested in taking a look at that, they can contact me, or I can get them into a little demo or a trial to walk through how everything works. Let's talk about some of the questions we had today. Actually had quite a few. One of the original questions was when I was talking about the FTC's update, somebody asked what the FTC's position is on debt collection calls using robo-dialers. I know that the bill that was introduced would allow robocalls to some extent if that gets passed. Joe, do you have any sense on what their view on the robo?
Yeah, when you're looking at the Federal Trade Commission, and what jurisdiction does the Federal Trade Commission have? You're looking at telephonic solicitation. So the FCC's rules regarding pre-recorded calls apply to telephonic solicitation. So if you're looking to get make pre-recorded telephonic solicitations of people, yes, you have to get express written consent. Outside of that arena, then you're impacted by the FCC rules, and that's what people are struggling trying to figure out. All right, where do they apply? Where do they not apply? Requiring the FCC to issue a separate ruling just with regard to debt collection, and so that's where the issues appear. For sales calls, that you have to worry about the FTC. For non-sales calls, then you dip into the FCC rules.
Here's a good question. Can a telemarketer respond to a customer inquiry if the customer is on the internal DNC list? Respond to an inquiry. I would say the answer would be no, not unless you've garnered permission from the consumer.
Yeah, there's no yeah, there's no separate inquiry exemption for the internal do not call list, and maybe that. And I hope I don't live to regret saying that and turn out to be wrong, but yeah, the inquiry exemption applies to the national do not call list. And I guess the assumption of the FTC and the FCC, for that matter, is that once a person goes on the internal do not call list, you really just shouldn't contact them. However, let's say you get express written consent from that person. Yes, make a phone call to me. I would say go ahead and call that person, because that express written consent will be sufficient under, in my opinion, any circumstances to enable you to call that person, even if they're on your internal do not call list. And as a secondary point, I just want to say a lot of people create their internal do not call list and then keep it, and don't attempt to pare it down in any way, shape, or form. And what I believe, even though it's not spelled out by the FTC or the FCC, I believe that much like the national do not call list, where disconnected and reassigned numbers are being taken off that list on a regular basis, I think that companies should do the same thing to their internal do not call lists as well.
Yeah, and I've heard companies that will call back inquiries that are previous internal DNCs because they're fresh and they're going to make a one-time pass because that's a primary source of their business, and their previous internal DNC registry matches to another name, it's older, etc. The real issue about that is that there's a lot of professional plaintiffs out there these days, and they are very good at setting telemarketers up. That's an easy setup. Opt out of everything and then opt into everything and see who calls you. So, you know, it's not always the FTC, the states, it's these, you know, make a few bucks, think I'm an attorney, going to sue you, and file with a couple other people. So that's something to watch out for. The next question actually corresponds to what you were talking about on internal DNC and about the federal list. Somebody asked what, now that they have somebody that's managing a list, they have plans to actually begin taking numbers off the list. Some people cancel phone service. And I'd actually asked the FTC that similar question in the session. They didn't really give us a whole lot of insight into that other than I was looking for kind of an idea how many numbers are coming off the list. She just basically said, look, we have a process that the numbers go through. She really didn't give a whole lot of details around it. But in talking with some other people at the ATA, they do know that that process is occurring. And I'm not sure to what extent they really are taking a huge amount of numbers off. But I had a phone number 3 or 4 years ago that was on the list when I moved into a new place. I moved. I took the number with me. And I just realized actually this morning that that number that I still have, it was actually removed from the do not call list.
Oh, interesting.
It took them a while to do it, but
you hear that, everybody? Ryan is not on the do not call list.
I'm trying to help jobs for America.
Exactly. Beautiful.
So I think what I've heard is that they are imploring. They have a vendor that does it. It's a private company that actually removes the numbers. But what I've heard is that they are reluctant to remove numbers. Obviously, you see what they come out with in their data report. The first couple things are, look at how many numbers are on the list. Since we put it in every day, I don't see a whole lot of difference in that database.
Yeah, I just feel very strongly that that there's no fault could be found with an entity that does that gets rid of reassigned and numbers and disconnected numbers on its internal do not call list. You know, I've heard of companies that have internal do not call lists of just millions upon millions of numbers. And they've had it going back, you know, ever since the TCPA was first passed. And I just don't think that's required. And to the extent that, you know, there's a mechanism out there to remove those numbers, I say go ahead and do it.
And somebody asked how many numbers or what percentage of the U.S. is actually on the DNC list. It's tough to tell because there's a lot of cell phone numbers and business numbers on the list. But I can tell you when, like, I have a client come on board and they'll take an initial list. It's fairly raw. Let's say it's just homeowner data and they're going to want to purge it for DNC. You can expect 50, 60% loss on that file, maybe more. Depends on, you know, we've seen a lot of the companies that market to higher income people, like the higher end timeshare market. They lose a lot of data in there because a lot of those people tend to be on the list. And in talking to people, that's one thing they didn't realize is that, you know, 7, 8 years down the road now, you see, you know, most of these people that are not hard to get on the do not call list, but the people that aren't on the do not call list, you know, sometimes aren't the people that you always want to target. So, I mean, it's tough to tell what percentage of the U.S. available landlines are on the DNC list, but it's a lot.
Yeah.
There's my scientific answer.
Nice.
Let's see if we got a couple minutes. There's we have questions on here. What entities are considered exempt from registering for a SAM? I think there's 4. There's nonprofit, political, information only, survey calls, maybe more than 4. Companies that do only business relationship calls or calls under EBR.
EBR, yep. Yep.
Where they just want to access the list just because they don't want to call people. If you go to the telemarketing do-not-call.gov website and you look at their exempt entity list, they do a pretty good job at spelling that out. So those are the ones that
Yep, you hit all the right points there.
Next one is one of those really long, complicated questions that we'll follow up on.
Okay, good. Yeah, don't even read that one. We'll just follow up on that one.
Yeah.
I like the easy one. Give me an easy one.
It has to do with cross-selling and upselling and third-party vendors. So,
oh boy,
too many moving parts. Joe,
cross-selling, upselling, third-party vendors. All right, go ahead.
To know if we're familiar with the proposed settlement in Gutierrez versus Barclays.
Ryan, I thought you were covering that one.
I thought you were covering that.
You know what? That is a very complex set of issues, and we're gonna have to take that one offline. All right, sorry. To be fair, to be honest, no, I'm not familiar with that, and I'll take a look at that just to see what's going on with the issues there. Don't even know what issues are addressed. Haven't even heard that case before.
This is a question that is a good kind of recap on the cell phone issue. What is considered express consent when calling cell phones? Is there a difference when calling a cell phone between a transactional call versus a sales call?
To the first question, so it's interesting, heading up to the Compliance Officers Forum at the ATA, there was just an ongoing conversation going back and forth amongst the panelists as to, well, what is the definition of express consent? And despite, a lot of searching and going through FCC materials trying to find what they consider to be express consent, the FCC has not opined on specifically what they mean by express consent. And so Reed Hauser from Citel, who was on the panel, he very intelligently defaulted to the dictionary definition of what express means. And I don't know the exact definition sitting here right now, but basically express means clear and, well, just very clear and without a doubt that the person is providing consent, then you have express consent. Yeah, of course, this is a key issue, but it's a double-edged sword. If the FCC came out and said, okay, this is exactly what we mean by express consent, that might limit the options available to the telemarketing industry. I much prefer to say, well, express consent means, it's certainly broad enough to cover whatever campaign I'm opining upon for a specific client. As long as the FCC does not set up a definition of that term, then the industry has some leeway to try to, fit different campaigns into that, into what we consider to be express consent. So hopefully I answered that question.
And I think Reed got the definition from Black's Law Dictionary.
Oh, that is true. That's correct.
So there's your source. Complicated. I'm looking for one last one. Oh, here's one. This is actually came up in the course of the compliance officers panel. The wonderful question of preview dialer. Preview dialing. When using a dialer, is it considered acceptable to call cell phones in preview mode if the only number provided on a website or agreement was a cell phone number? We asked this question on the panel. We got 2 yeses and 2 no's. I think was
right. And as a matter of fact, if anybody on the phone wants to go to dnc.com and take a look at newsletter articles that I've written, I wrote an article specifically addressing this issue, where I come down very strongly on the side of, yes, preview dialing falls under the rubric of manual dialing. And there are reasons for that, and I believe completely defensible reasons for making that conclusion. The key factor being human intervention. In preview dialing, the call does not get made, even though, yes, you have a machine that has the capacity to dial a whole bunch of numbers automatically, sure, but based upon some of the things that I quote in that article, without, as long as you have an element of human intervention before that one phone call gets made, which is what happens under preview dialing, then it does not become an automated telephone dialing system. And if you were my client, you can go ahead and do that.
Yeah, I would agree with Joe's interpretation on that one.
Well, thank you.
Also because we're running out of time and I don't want to argue with him.
All right, good.
That's okay. We did have a couple other questions. One person wanted to know about the Argentina do not call list. It only applies to the city of Buenos Aires, and it's not a national program as of yet. So it's a very small list. I actually have a copy of it. It was a couple hundred records, I think, a couple years ago. Lots of questions about cell phones and some good information that we can kind of follow up on.
All right, and for those people who submitted questions that we didn't get to, just keep in mind that you need to dumb down the questions for Ryan and I to attempt to address them. No, that's not true. But Ryan and I will address those questions separately, and we'll contact you via email to come up with some answers for them.
Yeah, we're trying to take simple questions because normally we do our webinars in the morning and the afternoon time. It's more difficult to
think.
Dive it.
Yeah,
to think. That's it. Otherwise, happy Halloween to everybody, and hopefully the rest of the year won't be too scary when it comes to compliance.
Beautiful. All right, well, thank you, everyone, and thank you, Ryan, for the opportunity.
Thanks. Appreciate your help, Joe.
All right, bye-bye.
Bye.